Okay, we are in the broadcast. Good morning and welcome to Coffee with KC and Marty. We're still beta testing this platform and this information, but we have some great content for y'all today. Thank you for joining us. And, last time we were here, I know it's been a little bit of a longer break than anticipated, but what we had talked about last time was criminal law. We're not going to recap that. We're going to do a dive on a dive. I mean, that's a relative term, but we're going to be talking about the jargony words that come up in estate planning and reducing the confusion and misunderstanding on what the heck do I even do? And what do these words mean? And I think without getting these definitions, you not being able to overcome them, it's very difficult to advise clients and then for them to have recollections about. So with that being said, Marty, let's start talking about when you're doing just an initial client intake, and do you have a form? I'm sure you must, that says, who do you want to be your executor or your trustee or what have you? And do you find that clients are often completely daunted by these old British?
Yeah, you might not have seen me shake my head, but no, I do not have one of those forms that says, who do you want to be your testatrix or who do you want to be your trustee? Because nobody understands what that is. So I break it down into very simple English terms. Who do you want to make financial decisions for you if you are not able to, and you're still alive? Who do you want to be able to transfer all of your property if you die? Who do you want to be in charge of your stuff when you die? Okay, I don't think I use stuff on there, but I say assets. But a lot of times in my writing, like when I do a blog or something, I will say stuff, and then I will say this is a legal term.
Yeah, people get there's the house, right? There's the house. There's the things in the retirement accounts. There's the mattress that's full of money. There's the pickle jar that has the key to the safety deposit box. And then there's the things in the house, the Gutenberg Bible, the record collection, the whatever it is, the 50 motorcycles in the garage that don't run.
It's all stuff. Every bit of that is stuff.
The tchotchkes, the stuff. I love how you break it down in plain English because, the courts, well, I mean, let's talk about the jargon. The courts do require the jargon, don't they?
Yeah, to a certain extent. It depends on what we're doing. The legal documents require the jargon. All right. So your legal documents are going to have the jargon in it. It's going to say testatrix. It's going to say testator. Those are the people that are actually creating the wills. So if you are going to come to me and say, hey, I want to create a will, I want to create a trust, I want to create whatever, you are that person. All it is you're the one I am a testator, or when you are the testator or the testatrix, if you're a female, it's the only difference. Testator, testatrix.
Right.
That means you are the one signing the will. Okay, so you are the one saying, I am giving all my stuff. That's all that means. It's you. You're the one doing that. Okay?
Right.
And it gets a little trickier sometimes, depending on where you are, what state you're in, and what the legal term is state to state.
Yeah, there's differences, but generally it means the person who's attested to or made the will or given the legacy, whether that's a trust or a will or a gift or whatever, right? That's that
right.
broad form.
And you used a couple legal terms inside of describing the legal term. So yes.
I know, we can't get away from it.
You made a test. Yeah, you testified. You tested. Yeah. You're the one that signed it. You're the one that said, hey, this is what I want. Okay.
Right on. And so, but there's other ones that, let's just talk about something simple like the person who's designated your attorney in fact as power of attorney. What the heck does that? I mean, there's so many little bits in that bit.
Yep.
That there's got to be a lawyer joke in there somewhere, right?
But
what is actually
attorney in fact? Why are you my attorney in fact when you can't even be you're practicing an attorney, right?
Right.
Who can be an attorney in fact if we're practicing? So anyway, besides the jokes, so yeah, a power of attorney in fact, that's a person that you're saying you want to help with your financial issues if you are unable to. Okay, being unable to, we can throw out the big word incapacitated, or we could say like Alzheimer's. You had a stroke, you're unconscious, you're in a coma, not dead, but cannot do your own financial planning.
Can't write checks, can't pay your bills, need someone to help manage your affairs.
Whether you're mentally impaired or physically impaired, or just don't want to do it. Yeah, there are some people that say, I'm going on vacation for 12 months. You take care of my financial affairs. I am appointing you as my attorney in fact, power of attorney. Go for it. Which means, hey, take care of my finances for me, will you? For me, not for you. If you do anything for you with my money, you can be criminally responsible, civilly responsible. It's a big deal. So it is a very, very powerful document, and it's a big deal. So it's a big responsibility for the person taking it on, and it's a lot of trust handing it over to somebody. So you got to know who that person is.
I love that. I love that because that kind of gets us into yet another big jargony word, because we mentioned duty, but there's actually something bookended on the front of that person who holds that power.
Right. And I didn't use the word, but
you
have a fiduciary duty, which means you can be held responsible for doing something not for my benefit. If I'm the one that gave you the power of attorney, I'm the one that gave you that fiduciary responsibility to take care of my finances for me. Now, if you don't, and you don't take care of them for me, so you go out and buy yourself a car with my money, and it's not for my benefit.
My Lambo is for your benefit, buddy.
Maybe I said go buy yourself a car so you can take me to my doctor's appointments.
Right.
Okay? If you bought a Lambo, that probably wouldn't work. If you bought a little van or a car that I could get into, it would probably be sufficient. It would probably be okay.
Yeah.
And you know, it depends on what that is.
Yeah, that's clearly one of those big ones. It's a big gray area, and it's why it's so critical to think about. You know, that word comes from trust. It's a Latin, Norman, English word that means origins mean in trust. In other words, you're holding this power in trust. For Marty Elberg, KC, you cannot go buy a Lamborghini SUV and write that off somehow as for the benefit of Marty, because Marty can't get in with his powered walker in and out of the Lambo SUV, as comfortable and safe as that vehicle might be. Moreover, $300,000 super SUV may not be the most, maybe you just ought to think about something more affordable that has, like a Dodge minivan or a Ford minivan. Again, because I hold the power that Marty gives me to manage his affairs, right? Let's assume I'm that person, but to manage your affairs, I hold that power in trust, and I have that highest duty, like you talked about, to not abuse that, not self-deal and line my pockets with the resources that are needed for your long-term, or even if it's short-term care.
Right. And it can be a short-term or long-term care. Like I said, I gave you the example of I'm going on vacation for 12 months. Take care of it. I'm going on vacation for 2 months. I'm going to the Antarctica where I'm not going to have any resources. Please take care of my things for me.
All I can think about is Rocky when he went to Russia to train, and then the next movie, the lawyer ripped him off, right?
No, his brother-in-law.
His brother-in-law. So
he didn't rip him off. He didn't rip him off. He just didn't know what he was doing. He got ripped off.
That's what it was. Yeah, they put all the money in Kodak stock or something.
Yeah, something weird. Yeah. So
that gets us into some other designations, titles of, and positions of this highest level of trust when you're creating that legacy, when you're creating the will and when you're creating a trust, and those we'll just do one at a time.
You mentioned a trust a couple of times. All right. So a lot of people have misconceptions or conceptions of what a trust is, what a trust isn't. Well, there are two main kinds of trusts. And inside those two main kinds, there are several different variations. All right. So the main types are revocable trust, which means it's a document that we say, hey, we're giving all of our assets and we're going to put them in this box. Okay. Picture a box. We're putting all of our assets inside the box. And think of the trust as the box. Okay. It's an instruction manual on how to manage the assets inside the trust. A revocable trust or a living trust or a revocable living trust, pretty much all the same thing. Okay. Mm-hmm. You can change that at any time. You own it, you manage it, and you benefit from it. Everything inside that trust, that box. Okay.
Yeah. Yeah.
So that's one kind of trust, is revocable types of trust. The other kind is irrevocable trust. Irrevocable, which means you cannot change without a whole bunch of work to get it changed. You either have to go to court, you have to have everybody that's listed inside that trust agree that it gets changed, and it's for a lot of different reasons. It's for either tax purposes, it's for asset protection purposes, it's for asset growth. There's a lot of reasons for an irrevocable trust. But 99 as of right now, while we're in 2021, where the estate taxes are still really, really high. They're almost 12 million per person, 24 million per couple. So 99.9% of the country doesn't really have to worry about an irrevocable trust, at least for tax purposes.
Right.
Okay. For estate tax purposes. Estate taxes are when you die and you have over this amount of money. So as a married couple, 24 million, single, 12 million. It's actually less than that. It's like 11.89 or something like that right now. If you have more than that, then the government's going to come and they're going to say, hey, thanks for my 40% of anything over 12 million.
Right.
It's a big deal. So it is a good idea to get that planned for. But like I said, 99.9, probably 7% of the population doesn't even need to worry about that right now. So
let's talk about the jargon that goes into, you don't call them a testator. What do you call them? And who's in charge of the money?
Perfect. All right. So there are three roles to a trust, or three main ingredients to a trust. There's a trustor. Okay. That's the same as like your testator or testatrix. Okay. So trustor.
Created.
Which has three names in itself. Okay.
Right.
This is where it gets weird. Trustor, grantor, settlor are all the same role. Trustor, grantor, settlor. Those are again, same role. That's the person that owns the property. So I have this house, and I'm going to put it into my box. So once I put the house into my box, I used to own it. I put it in there. I'm the trustor. Settlor, grantor. Owning the property, putting it in the box. Now that it's in the box, now we need somebody to manage the assets that are in that box. Okay. So that person is called a trustee. The trustee manages the assets in the box. That means they buy real estate, they sell real estate, they invest the money, they spend the money, they spend money on fixing up assets, they do the proper investments, they do whatever they want. Okay. So now we have trustor, settlor, grantor, one role, trustee, the manager. Okay. And the beneficiary is the final role of the trust. And that's the person that benefits from the trust. So if it's a house I'm talking about and it's my trust and I get to live in the house, I get the benefit of living in the house. If it's an investment and there are dividends paid, I'm the beneficiary of that. That means I benefit from that investment. So I get to rejoice in all of my stuff that I have in my box. So that's what we have, and that's what a trust is. And a lot of people make it out to be so complicated, and it can be if you read all 20 pages of it. If you skim through it and say, Marty, what do I look at? What should I look at? The first 5 pages is really what's going to control your assets and where they go. The rest of it is just to protect you and your people you're leaving behind, and you're leaving the assets behind for. So
right. Those are called what? Those people are they?
Those people are called, the legal term is contingent beneficiaries. So they are people that you leave behind. So I'm the beneficiary of my trust right now. I benefit from it now. When I die, I leave it to, well, it would be my wife and I. So my wife and I are the co-trustees, co-beneficiaries of our trust. So when both of us die, it goes to our kids. And if one of our kids dies, then it would go to their kids.
Right.
And it's held, and then remember I said the rest of that 20 pages is for their support. So if they're under a certain age, then they don't get that money straight out. Let's just say I had $1 million in there. If I die and my wife dies and there's $1 million in there, it doesn't just automatically go to them. We can have paragraphs, provisions. That's a kind of a legal term, but most people know what provisions are. Provisions in the trust that say, hey, if you're not 30, you don't get this straight out. You can have it paying your health for healthcare, your maintenance, your education, daily type of expenses.
Stair step it up so it does not get spent on Corvettes and beer.
Exactly. Right. And then we say, I usually have it staggered out for 25. At age 25, you get a third of whatever's in that pot or that box. At 30, you get half of whatever's left. So another third. And at 35, you get the rest. Some of my clients say, no, I want it to be 35, 40, 45, 30, 30. They like the staggered approach because, that first chunk, it's like, oh, wow, I got all this money. I'm going to go spend it. So you got to be careful about giving everything to them. And one of the really important things about it is you never want to leave assets straight out to somebody that's under 18 or 21, depending on the amount of the assets, because then we create a need for a whole nother subject, which is probate and guardianships and things like that. So a trust is the best vehicle to ensure, to make sure that you're never in that situation. You don't have to go to court. You don't have to spend the thousands of dollars to go to court to get your assets. You don't have to spend the thousands of dollars and months in court to get supervision over the money for a minor child if you leave it to them. So a trust is a perfect vehicle to make sure you don't have to deal with the court system, or the ones you leave behind don't have to deal with the court system.
Awesome. Well, we're approaching the top of the hour, and I'm gonna give us the hook. Appreciate you doing this with me. We'll do another.
Can I?
Absolutely.
30 seconds. Okay. So because we talked about the things the labels when we're alive and we're creating these things, let's talk about 2 when we die. Okay. So when we die, you might hear executor. Executor is a person that takes care of all the stuff and takes it through the court system to get it to whoever you want. Okay. That's executor. Also called a personal representative, depending on what state you're in. So that's what that is. Okay. If we're dealing with trust assets, it's called a successor trustee. So that's somebody that would take care of the stuff after I die. Somebody is appointed and they go, but they don't have to go through the court system. So
big difference there.
Those up. Yeah. Figured we'd go alive to dead and wrap it up that way. Now you can wrap up. Thanks.
Hey, any other save thoughts?
No, well, there's a lot. There are a lot of terms, and it really is important to understand what they are, which is why I really hate online wills, online estate planning, because they take you through a 5-question questionnaire and they say, oh, okay, you should have this. I'm like, really? Oh, wow. I know that. I know to say, oh, really? Wow. Because this is what I do day in, day out. But
yeah, they can
no.
Yeah, they can leave a lot of stones yet unturned.
Mm-hmm.
And things can be missed, or the client doesn't have the information, and that's one of the reasons why having somebody like you on their team is so critical.
Yep. Might cost a little more, but it's gonna cost a lot more up front, but it's gonna save you a whole lot more, or your family a whole lot more in the end.
Right. On that worst hard day, that their job will be easy. It will be It will make sense.
Exactly. Go ahead and mourn the death of your loved one instead of worrying about hiring an attorney and going to court.
Right.
That's what I do. I try to make it so families never have to worry about me when they die.
Right on.
Leave a legacy, not a mess.
Love it.
Yeah.
Love it. All right. Well, until next time, thank you, Marty. We'll download this and share it and get it out on the interwebs. It's on YouTube right now, and we'll reconvene next week.
All right. Awesome.
All right. Thank you.